Mr. Smith, are you ready to continue?
Yes, ma'am.
Ms. Menaka? Yes? Excellent.
Let's go back a slide 37. We're going to start talking a little bit about manifest lack of independence and impartiality. So here I'm going to address slides 45 to 47. And really what I think is what's happening here is this honest exercise of discretion is really being stretched far too broadly. First, it sort of builds on this notion of what's publicly available that we've already disclosed or already discussed. And I think it's also contrary to this this lecture by Ms. Lamb. We heard a little bit about that yesterday and how there was just a power of attorney. It's actually we included some cites. It was a little bit more than a power of attorney. But I think the important thing that we see in that lecture is just the frustration whenever manifest lack is connected to the kinds of things that a party has to find and that don't have to be disclosed, right? That's what we really see in that, and you can see the date that is given in January, I believe, of 2022, when the decision that was rendered in Grupo Unidos por el Canal was November of 2021. So I think you really see that frustration coming out, or at least the article was published on January 5th, 2022. But that's where you see that frustration. And I don't think that it's all too helpful just to sort of gloss over the fact that this is a challenge that is faced by counsel, and shifting it to counsel and away from the arbitrators, really is the kind of thing that creates a lot of consternation. Let's go down to slide 39. Here we pick up, we're talking about slide 49 of the presentation from yesterday. And really what you're seeing here on this slide is you're seeing that arbitrator specific test that we just started mentioning right now. And you can see it in the first two sort of text boxes where Dr. Lexendorf saying, I considered and I do not believe. And then the third one in Meisen, Dr. Lexendorf also stated that he believed. There is space for what an arbitrator believes. But whenever we just go solely off what the arbitrator believes, then we change our test and move it completely to the arbitrator and not and what that individual's subjective belief is. This is especially troubling because Dr. Lexendorf in those three cases disclosed in three different ways, right? So TCC, we have 4 cases. In reality, it was 15 from Soles. And then in Meisen, he voluntarily disclosed 2. I wanted to speak briefly about Meisen. It was cited a few times yesterday. Something that caught our eye from Meisen is really goes against the argument that we heard, which is that if the standard is going to be, and this does speak to disclosure, but it can also speak to manifest lack. If the standard is going to be what the arbitrator thought, then in Meisen, why did Dr. Lexendorf disclose anything, right? I mean, if he really thought that it was publicly available or somehow didn't need to be disclosed, he wouldn't have disclosed it. Now, he can retain his individual belief, right? His subjective belief can continue to exist, but that doesn't change what the actual standard is and what we should expect from arbitrators whenever they make their disclosures. Let's go to slide 42 in the presentation. Here we're talking about, this refers to slide 51 in the presentation from yesterday. There was a reference to Vivendi 1 and Vattenfall 2. The important thing about Vivendi 1 is Professor Kaufman-Kohler did not know about the conflict at issue when the disclosure wasn't made, right? Whereas here, Dr. Alexandrov clearly knew about something, right? Whether he might have had a subjective belief is one thing, but he certainly knew that this was an issue. His connections with experts were an issue. Sorry. That's actually Vivendi 2, but it's cited Vivendi 1. Let's talk about Vattenfall real quickly. Here, first we have to consider what the challenges were. The challenges I would say were kind of weak, but for example, a decision to proceed by video conference. These are pretty minor issues that were raised by Germany, so it's unsurprising that you see a decision that isn't too favorable to them. But I think that the thing that really jumped out at me from Vattenfall 2 is here you have the Secretary General of the PCA actually being supportive of ICER, saying as quote, as I understand ICER, it stands for the proposition that a award may be annulled where an arbitrator is found to be conflicted and thus lacking the capacity to exercise independent judgment after the proceedings were concluded. Right. So you heard yesterday about a critique, an implicit critique. We're going to get to that. But when we think about the implicit critique that might have existed, it's also important to consider that here we have the PCA taking a different position and really being supportive of ICER after the recommendation that was issued in TCC versus Pakistan. Next slide, please. Slide 43. So there's a lot of talk about what was supposedly speculation and what is not. So let's look at the IBA guidelines on the conflicts of interest. You know, Professor Jones was of course very helpful on this topic yesterday, and I think that what we need to remember when looking at the IBA guidelines, and that wasn't mentioned yesterday, especially if you kind of take what is, I would guess, to be presumed from slide 52, which is sort of the absence of something being listed on the orange list or any list would mean that it's okay. Of course, that's not what the guidelines say. It is on a case-by-case basis. And so that's, this argument in of itself cannot stand. Also, when speaking on this slide yesterday, there was a reference to Article 6.2, but the reference was only to Article 6.2a and the connection between these guidelines and the parties, right? And of course, Article 6.2b, which is the remainder of that, that sub-article, goes much further, right? And to any other circumstance.
Your first sentence on this
Yes, sir.
slide,
Mhm.
Is that correct?
The relationship does not have to
Orange
be.
list situations are generally not subject to disclosure. Is that correct?
Well, that's what it says in the guidelines. And I think that's why it's followed. And I think what they were trying to, I mean, well, sir, I'm not going to, maybe I'd be a little bit out of place to presume what you were thinking whenever this was put together. But yeah, what I think what the drafters were trying to say is that there's going to be some things that are not on the orange list. And if you continue, but we're not creating a code.
My view is you disclose everything on the orange list.
No, I agree. I totally agree with that.
And the whole point of doing this exercise was to have a green list. Because no one could get appointed as a chair in an ICC matter
Okay.
if they made any disclosure.
Gotcha.
So the whole concept was to have a green list that you didn't have to disclose so you could get ICC appointments.
Well, thank you. That's very helpful. And I guess in that sense, it was effective, right? It did help to kind of clear up some of the conference.
Except the ICC have now changed their view completely.
Okay.
Because they want work in the US where you disclose everything,
Yes,
including
you're
who your grandmother went to kindergarten with.
correct. Yes, that is correct. I guess I can't take responsibility for that, but anyways, the point is that the orange list really calls for a case-by-case basis, and that's what we're doing here, right? So it's non-exhaustive. There can be situations not mentioned, which, and I'm reading here, depending on the circumstances, may need to be disclosed by an arbitrator. So just important to refer to that. And the Professor Jones, that you know far more about this than I do. So let's keep going and go to the next slide. Slide 44. Yeah, there is some confusion, I think, that's created regarding TCC versus Pakistan. I don't really want to spend a lot of time on this because it's pretty apparent just from the text of those decisions and the order in which they were issued and what ICSID thought about TCC. But of course, ICSID only saw the first challenge, not the second. So taking ICSID as dispositive of TCC is to really not give that committee a chance to see all the facts. Next slide, please. Sorry, mine's a bit slower here. Okay. Let's talk to about some of the concerns that were raised regarding ICSID. Here we're on slide 58. The title of the slide is that the ruling is an outlier and widely criticized. Then you have reference to one sentence in Gary Bourne's book on international commercial arbitration. And then you have one sentence in a footnote. Notably, there's not much here, right? That's basically it that was written. This isn't like a long description of why Mr. Bourne didn't like the decision. The next article seems to be based on how much money had been spent by the parties. And once they've gone long enough, then awards shouldn't be annulled. That doesn't seem too terribly convincing. And then the third one about how the decision would make arbitration almost unworkable hasn't proved to be true. 2 years on, we're all seem to be doing pretty well. Next slide. I wanted to get real quickly to the argument that was made yesterday that ICSID was somehow overruled, not overruled, implicitly criticized, I guess, because it can't be overruled, right? And there was a reference to what the chairman of the administrative council had decided in Meisen, and the argument is, as I took it, was that by citing to ICSID and then coming on later to say or to decide not, I think that was to apply it, but that's not an implicit criticism. In reality, it looks a lot more like it's following ICSID, because that second sentence says, however, the respondent does not argue that this conclusion applies. So by virtue of using the word however, it seems to make a distinction between what is the test and what was argued. And here it just wasn't argued. And so that's not really an implicit criticism. Also, it seems unlikely that if the chairman wanted to criticize ICSID, he or a future she would do so implicitly, right? He doesn't need to be implicit about it. It can just be explicit. Next slide, 48. So here we're talking about...
Maybe just pausing there.
Yes, sir.
Since we're on the this particular decision,
Yes, sir.
the chairman of ICSID,
Mhm.
administrative chairman.
Yes.
What kind of weight should we give it, or is it a policy statement that he's making here,
I mean, I think that
or is it just another decision that we should just consider?
I think it's a decision to consider. I mean, there's always this, the way that I see decisions in international arbitration is that we look at them for their persuasiveness, because there's no real precedent. And so we try to determine how persuasive was this thing based on the way it was drafted. And so that's the way I would take this one or anything else. But I think that it would be important to, there was the question raised this morning that I guess we're all going to ruminate on, and that's the ICSID Uncentral Code of Conduct. And so I think, from that, we are seeing certainly a direction. And that direction, you can see it maybe perhaps coming through in this decision that isn't going out and, directly criticizing, but rather criticizing how the party pled the case. So let's look at slide 40. Where are we? 47, there was an argument about how there's experts and that we have to have, I guess, essentially a smaller number of them. You heard this morning from Dr. Tortorola talked about the value of having Judge Hasher and Iser to bring that different viewpoint. I think we do the same when we talk about having new experts or new arbitrators. So we're not looking to create some sort of barrier to entry, I would guess, for experts. And there's plenty of great experts out there that we can draw on. Next slide. Let's see, 48. There was a lot of talk about speculation. I'm not going to get into this. The slide speaks for itself. You can talk about it. I'm running a bit short on time. But, you know, there was a statement that Mr. Kaczmarek was hired by tender. It was a direct contract. At Peru, I reviewed those documents last night. I don't see how they'll stand for the contracting of Mr. Kaczmarek. Next slide, please. Talk briefly about Navigant. The argument on Navigant appears to be that there was no representation of Navigant from 2010 to 2018. That's not it's not accurate based on that slide. And I think that the point is here that we don't actually know. Not all representations are disclosed to the public. And there can be plenty of advice on things that we don't know about. The other issue is really just what it means for that hearing. And we talk about the longbow, we talk about fiduciary duties to a client. You know, how do those look whenever it's your client testifying, right? And that's not really been addressed. Next slide. I've already talked about this. So I wanted to be in closing, the one thing that I wanted to mention is just there was a slide that we saw yesterday. I'm going to get it for you quickly. And it talked about some, I guess, views of Mr. Blackaby. Where is it? What slide is it? $60. 58. 60. Yeah, slide 60. And there was a citation to, it says here, the title of the slide is there a small number of quantum experts specializing in investment arbitration and interaction is inevitable. There's a citation to an article by Mr. Blackaby. It's important to note that article is dated 2016. So it is before the facts at issue in this case. So I don't think it would purport to include the entirety of Mr. Blackaby's views, especially when they predate the relevant facts. The other thing about Mr. Blackaby and what he might or might not have thought, you know, I mean, this argument really it presupposes two things. First, that we would know what he thought, which in of itself is, I would say, impossible to get to the bottom of, because he's not here to tell us, and it's not our job to ask him. And then the second thing is presuming what to do with whatever knowledge he had. We can't get into his head to figure out what he thought about it or his team thought about it. If he didn't, maybe it was somebody else on the team. And, their sort of belief as to what to do with that information. Of course, we cannot suppose that either. And to then imply that or impute that to Guatemala is really a bridge too far. So with that, I'm going to pass the word to my colleague.
Just before you do.
Please.
The issue of getting inside Mr. Blackaby's head
Mhm.
is a different question to what the tribunal might consider
Mhm.
is the normal responsibility
Mhm.
of a lawyer acting for a client in a contested ISDS matter,
Mhm.
relevantly in the context of a potential challenge to the arbitrator appointed by the other party. So if you have any submissions in that respect, it would be helpful because members of the tribunal, members of the committee may have views as to what the duties of lawyers are to their clients in this situation.
Well, yes, sir. I mean, I see your point, and that's a point that was raised yesterday. But I struggle to see how it still wouldn't involve the first part of the knowledge, right? I mean, the first part of getting into the individual's head. We still have to get to that point before we get to the disclosure obligation that might exist or what the individual thought about it.
Yeah, but I think it might be possible for the committee to conclude that Freshfields and Mr. Blackerby, as a leader of their practice in international arbitration, specialising in ISDS, would have been aware of all of the scuttlebutt surrounding the arbitrator. That would not be a conclusion difficult to be drawn.
Well,
you don't have to get into his head to do that.
Well, sir, but I think that we do have to the extent that it relates to Mr. Keksmarek, right? I mean, if you were to take that approach, and I think that that would be a part of it, and that the other part of it would be, sorry, just a second. So I'm sorry, we were just having a brief chat. So I guess the first thing is you have to apply it to this specific set of facts. And we're not talking about a situation where Browder was the expert. I still wouldn't agree with it then, because we're talking about the party's knowledge, right? And so you're only at the first step. There's a second step that comes after that. I think it's also we need to consider, what really has been the position on the rules that apply, right? What rules do apply in this context? And it's unclear, right? Is it the rules of somebody's bar where they are licensed? Is it some sort of, rules floating in the air? There have been suggestions that there are no rules at all. And so without, getting to the bottom of that, I don't think we can really get to the bottom of that answer.
I don't understand that point. What rules are you talking about?
Regarding disclosure, right? So what a lawyer must tell us his or her client.
I'm not talking about the rules of disclosure. I'm talking about the duty of a lawyer acting for a client who becomes aware of circumstances where there is a potential right to challenge.
I use the wrong word.
Arbitrator appointed by the other party in an ISDS case.
Yes.
Now, that is not a question of bar rules. It's a question of professional duties.
Sure.
In acting with due diligence.
Okay.
For the client.
Yes, sir. Well, and to be clear, when I said the word disclosure, I think I confused it, right? We're talking about the same thing. But even then, in the context of duties that exist, those duties are rooted in some form of law. And I think that you'd have to also establish, what was the duty that was breached? The generic duty that might apply. We don't necessarily have that. And we don't even have that. I haven't seen that on the record. So there are some further complications with that line of argument were we to follow it.
Please proceed.
Thank you very much. Good morning, members of the committee, Madam President, and opposing counsel and representatives of the parties. We will pick up the discussion where we left it on the issues relating to damages and the annulment grounds relating to the damages section in the resubmission award. And we have kept in the stock, which is thicker than we'll have time to actually go over with in detail. We kept a number of slides from yesterday's presentation that we have seen have not actually been rebutted in any significant way by opposing counsel, and so we think it still makes sense to maybe take a brief look to these issues. Committee will remember, of course, we have basically two series of grounds for annulment, one related to the alleged loss of value from the sale of EXA, one related to the issue of post-sale interest. And as we go through each of these issues, we have done our best to intersperse our response, a further response to the questions we received from the committee members yesterday, which is, of course, without prejudice to further elaboration once we have a fuller set of questions and in whatever format the committee allows us then to address them. But if there's any point in these answers which invites a further follow-up thought, please let us have it so that we can respond appropriately. First important thing, and we go to slide 53, as we mentioned yesterday, and we have to insist today, the findings from the first annulment committee in this case would suffice to annul the resubmission award verbatim. The resubmission tribunal failed to address in any way the parties' expert reports on the loss of value claim, despite the parties' strong emphasis on expert evidence, and ignored the existence in the record of evidence which at least appeared to be relevant to its analysis. This calls for annulment under Article 52 of the ICSID Convention. And we'll skip to slide 56 so that we get to a question that was posed by Professor Jones yesterday, which we have transcribed here. The question was whether, in order for reasons to be adequate, is it necessary for the choice of the experts to be explicit? The reference is in page 62 of yesterday's transcripts. Our short form answer is yes, because the actual value of EXA and the method to arrive at the same were necessary to the tribunal's decision on loss of value. And without such reasons, and in ignoring Guatemala's evidence, the resubmission award is annullable under Articles 51D and E of the ICSID Convention. And this is actually a position which TECO itself would have adopted if it was still following the arguments it made before the first annulment committee. We go to slide 58. We have here citations to paragraph 85, where they state that the Article 52(1)(e) of the ICSID Convention provides an award must be annulled if there's no statement of how and why the tribunal came to its decision in the light of the facts and applicable law, citing to Professor Schroyer and other sources. Paragraph 88. The reasons argument also extends to the tribunal's duty to consider or otherwise respond to the arguments and evidence presented by the parties. Citation to Wiener Hotel v. Egypt. Paragraph 87, the ad hoc committee, and this is a citation to Soufraki v. United Arab Emirates, insufficient or inadequate reasons as well as contradictory reasons can spur an annulment. Paragraph 106, one of the grounds for annulment that TECO was arguing in the first annulment proceedings is the tribunal had not provided an explanation as to why the interview of one source of evidence, this was an EPM representative, remember EPM was the purchaser in the October 2010 transaction, should prevail over the foregoing comprehensive documentary and expert evidence. And this was paragraph 106. We have listed yesterday already a number of compiled citations to TECO's first memorial on the first annulment proceedings, citing a number of paragraphs. Each of these reasons substantiates why